All right, I'm gonna go ahead and call the meeting of the Sentencing Guidelines Commission to order. Today is July 24th, 2025, and I will ask our director, Nate Wrights, to take the roll.
Do we have a quorum?
Thank you, Madam Chair. Roll call, Vice Chair Larkin.
Present.
Larkin present. Commissioner Castro.
Present.
Castro present. Commissioner Fraze. Fraze absent. Commissioner Keefe. Keefe absent. Commissioner Ladd.
Present.
Ladd present. Commissioner Mazzaros.
Present.
Commissioner Mazzaros present. Commissioner Middlebrook.
Present.
Commissioner Middlebrook present. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Moran.
Present.
Commissioner Moran present. Commissioner Mueller.
Present.
Commissioner Mueller present. Commissioner Reeves. Commissioner Reeves absent. Commissioner Saxena. Commissioner Saxena absent. Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 9 members present, 4 members absent.
And with that, we do have a quorum. First item on our agenda is adoption of the draft meeting agenda. So I would entertain a motion to approve the agenda.
So moved.
Commissioner Larkin moves and Commissioner Middlebrook seconds. And any discussion on the agenda? Hearing none, we'll go ahead and take the roll.
To the Larkin motion to approve the agenda. Larkin?
Yes.
Larkin, yes. Castro?
Yes.
Castro, yes. Fraze? Fraze absent. Keefe? Keefe absent. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves? Reeves absent. Saxena? Saxena absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item on the agenda is approval of draft meeting minutes from June 5th, 2025. They were all sent out a week ago. You should have all had a chance to review them. I would entertain a motion to approve the minutes.
So moved.
Commissioner Middlebrook moves to approve the minutes.
Second.
Commissioner Larkin seconds. Any discussion on the motion? Hearing none, we'll go ahead and take a vote. Looks like we also have an additional commissioner member who's joined. Keep.
Correct, Madam Chair. I just elevated Commissioner Keefe from attendee to panelist, and I missed who made the motion to approve the minutes. So
Correct.
who was that?
Oh, I'm sorry. It was Commissioner Middlebrook made the motion and Commissioner Larkin seconds.
So to the Middlebrook motion to approve the June 5th, 2025 meeting minutes, Larkin?
Yes.
Larkin, yes. Castro?
Abstain as I wasn't present.
Castro abstains. Fraze? Fraze absent. Keefe? Keefe absent. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves? Reeves absent. Saxena? Saxena absent. To the Middlebrook motion to approve the June 5th, 2025 meeting minutes. Fraze?
Yes.
Fraze,
yes. Chair Mitchell?
Yes, and it looks like
Chair
Commissioner
Mitchell.
Keefe is there.
Yes.
So
Oh, I'm sorry, Commissioner Keefe. What was your vote?
yes.
Commissioner Keefe, yes. So Madam Chair, there are 10 votes in favor, 1 abstention.
All right, and with that, the motion is approved. Before we go any further on the agenda, I do want to recognize that we do have our new trial court, district court judge member. It's Judge Lenny Castro. So if Judge Castro, if you want to say hello and introduce yourself to the group.
Good afternoon, everyone. I'm Judge Castro. I'm glad to be here. Let me know how I can help.
Oh, we'll put you to work. Don't worry.
I'm sure.
Do we, since we have a new member, how about, I know we all voted, but let's go around real quick and just introduce ourselves to Judge Castro. So Commissioner Mueller, would you mind kicking that off?
Sure. Good afternoon, Judge Brian Mueller, Chief of Police for the City of Stillwater and representing law enforcement on the panel.
Good afternoon, Judge Castro. Great to see you again. Judge Castro and I go way back to 5th District days when he was Chief Public Defender, and certainly I think we were in new judge school together all those years ago. So great to see you on board.
Thank you.
Kyra Ladd, I'm the Wadena County Attorney, and I represent the county attorneys on this board. And way back when, I was a law clerk at the Hennepin County Public Defender's Office when you were the Hennepin County Public Defender.
Nice.
And I am Catherine Middlebrook. We go back as well. Welcome, Judge Castro. It's good to have you on the commission.
Thank you.
Michelle Larkin, we go way back to the Hennepin County Public Defender's Office. I don't remember Commissioner Ladd, but I do remember you. You were my boss and a fabulous one at that. So I'm glad you're here.
Thanks.
And you know me as well, Kelly Mitchell, the chair. I've worked at DOC now, but we got to rewrite the criminal rules together. That was fun. Go ahead. Nate, do you want to go ahead?
Hi, I'm Nate Wrights. I lead the staff, Judge.
Marlon Nazaris, Director of Housing and Support Services at Partners Behavioral Healthcare, representing treatment providers and service providers.
Richard Fraze, hired University of Minnesota law professor and academic member. I was on the Rules Committee. We might have overlapped, but in any case, welcome to the commission. Good to work with you.
Thank you.
And then Commissioner Keefe.
Hi, I'm representing victims and I work at the Domestic Abuse Project. So while we have not met, I have heard your name many times through different advocates and things like that. So welcome. Glad to have you.
Commissioner Moran.
Hey, Judge, Tim Moran here. I'm a public member, the public member that sits in the seat that represents the people that got in trouble but corrected their lives. I'm currently a firefighter by trade, full-time, and just happy to meet you.
Good to meet you.
All right, I think that's everyone. Okay, so the main order of business today is to work through all of the changes to the guidelines that will be going into effect, in August or shortly thereafter, following our meeting today. So item 4, where we start, is review of the public hearing, and I'm going to turn it over to Director Wrights for that review of the public hearing record. Sorry.
Thank you, Madam Chair. So on Monday, June 16th, 2025, the notice of public hearing was published in the State Register, Volume 49, Number 51, and the contents of the proposed modifications were posted on the Commission's website. The same day, an email notice of public hearing was sent to persons who have signed up on the Commission's website to receive informational emails. No one was notified by United States Mail because there are no longer members of the public on the U.S. Mail list. Pursuant to that public hearing notice, the public hearing was held on July 17th, 2025 in this room and by telephone and or electronically. One person, an MSGC staff member, testified. No other members of the public wished to or did testify. After the public hearing, the record remained open for 5 calendar days through July 23rd to accept written comments. From the beginning of the public hearing notice period through the end of the public comment period, the Commission received 1 written comment regarding the subject of the public hearing. The complete public hearing record, including a list of those who spoke at the hearing, a link to the video and audio of the hearing, and copies of the written comment, was provided to all Commission members on July 17th, was posted in its entirety on the Commission's website on July 18th, and is included in today's meeting materials. The Commission appears to have substantially complied with all public notice and hearing requirements to permit it to take final action on the proposed modifications today, Madam Chair.
All right, thank you very much. So the next item on the agenda is acceptance or rejection of the proposed amendments. And so what we're, okay. Nate gave me some good talking points to help me through this because it's complex, but I was already deviating. And I just need to stick to it because it's easier that way. All right, so so all of the proposed amendments received the commission's preliminary approval. They've gone through the public notice and hearing process. They're ready for us to do final approval. The changes that are approved today will generally take effect August 1st, which is next Friday. Staff will be publishing the new annual edition of the sentencing guidelines on that date. So we did only receive one public comment, and that was actually from Nate to help correct some discrepancies in the areas that we preliminarily approved. So what I'm going to propose is that we split up the votes. So we're going to first deal with the items that had no public comment attached to them. And then we'll move on to the two areas where there were public comments. So that way we'll essentially have 3 votes by the end of this, but that seems like the cleanest way to go about it. Okay. So beginning with the proposed changes for which there was no public comment. If we use the numbering system that's in the notice of public hearing, these changes are in Part A, relating to 2 new crimes that were created in the 2025 session. Part B3, relating to codified minimum sentences for sex trafficking. Part B4, renaming child pornography as child sexual abuse material. And then 2 technical corrections in Part C. The specified effective date of Part A1 is January 1, 2026. The remaining will be effective August 1st, 2025. So assuming that you're all okay with going this route, I will now entertain a motion to approve the proposed modifications in Part A, Part B3 and B4, and Part C of the Commission's June 16th, 2025 Notice of Public Hearing.
I'll make that motion.
Commissioner Larkin makes that motion. Do we have a second?
Second.
Commissioner Fraze makes seconds. Any discussion on the motion? All right, hearing none, we'll go ahead and take a vote on those changes.
To the Larkin motion to finally approve the proposed modifications in parts A, B3, B4, and C of the Commission's June 16th, 2025 Notice of Public Hearing. Larkin?
Yes.
Larkin, yes. Castro?
Yes.
Castro, yes. Fraze?
Yes.
Fraze, yes. Keefe?
Yes. Yeah.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook? Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves? Reeves, absent. Saxena? Saxena, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, thank you. So now we're going to move to Part B1. So this is relating to the new criminal penalties for exposing children to fentanyl. So Director Wrights made public comments in which he now proposes to list the new crime of exposing a child to fentanyl separately from the existing crime of exposing a child or vulnerable adult to methamphetamine or related chemicals, and to list the new crime on the list of offenses eligible for permissive consecutive sentences. Director Wrights' written comment, which is in the public hearing materials, contains alternative draft language to that was found in our original notice of public hearing. So I'd like someone to make a motion. You have a couple of options. You can either say we adopt the original, or you can make a motion to adopt the new language that Director Wright proposed in the written public comment, unless you have a third option. But those would be the main ones. Okay. I saw Commissioner Middlebrook first.
Oh, yeah, I'll move to adopt the alternative language that came through on the public comment.
Okay, so a motion to approve the alternative language in the public comment. Do we have a second? Anyone? Do you say second? Commissioner Mazzaro seconds. Any discussion on that motion? All right, we'll go ahead and take a vote on that.
To the Middlebrook motion to finally adopt Director Wright's alternative language to Part B1 of the Commission's June 16th, 2025 notice of public hearing. Larkin?
Yes.
Larkin, yes. Castro?
Yes.
Castro, yes. Fraze?
Yes.
Fraze, yes. Keefe? Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves? Reeves, absent. Saxena? Saxena, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, so now last one is the proposed changes in Part B2. So this relates to there's a new law passed requiring a consecutive sentence requirement for assaulting a sheriff or sheriff's deputy in jail. This requirement is found in Minnesota Statute 609.2232, new paragraph B. Okay, so Director Wrights made a public comment in which he advocates limiting the proposed guidelines language, saying that new paragraph B always requires an executed sentence. And he also proposes different language for incorporating the new paragraph B into the guidelines consecutive sentencing policy. Director Wrights' written comment is in the public hearing materials, and it contains alternative draft language to that which was published in our notice of public hearing. So here again, I'm looking for a motion. The options are to go with the original language that we had put out in the notice of public hearing, to adopt the alternative language that Director Wrights proposed in the public hearing, or if you have a third alternative, that is also fine.
I move to adopt the alternative language.
Commissioner Larkin moves to adopt the alternative language. Do we have a second?
Second.
Commissioner Moore seconds. Do we have any discussion on the motion? All right, hearing none, we can vote on it.
To the Larkin motion to adopt Director Wright's alternative to Part B2 found in his written public comment to the Commission's June 16th notice of public hearing dated June 16th, 2025. Larkin?
Yes.
Larkin, yes. Castro?
Yes.
Castro, yes. Fraze?
Yes.
Fraze, yes. Keefe?
Yes.
Keefe, yes.
Yes.
Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves? Reeves, absent. Saxena? Saxena, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. And thank you, Director Wrights, for bringing forth the public comment. Those are two really complex issues, and I appreciate you noodling on that and thinking it through and helping us to put together a better proposal for the guidelines.
You're welcome, Madam Chair. I wish I had caught it the first go round. I apologize for that.
No worries there. That was a really complex law. All right, we are now going to move on to item 6, which is the comprehensive review ranking projects results for offense group 3. So I'll invite Leah Bauer and Matt Helna forward to walk us through that.
All right, just take one moment to bring up the PowerPoint.
Almost there.
Almost there. All right, so we are going to talk about offense group 3. So this is similar to the process we went through with offense group 1 and offense group 2. You all completed a packet of 18 offenses in this offense group 3, which included assault charges, domestic assaults and violations, and ag robbery. You completed those packets and sent to us on June 23rd, and we compiled the information that we are now going to go through. So Matt and I are going to go through this. We broke the 18 offenses into 8 subgroups. So we'll be talking about those subgroups each, and then have some time for questions and discussion. So we're going to jump right in with assault 1. This group is only one offense, great bodily harm. It is currently ranked at severity level 9. And you can see here with the graph that the most votes, 7 of them were for downranking this offense, followed by 5 votes to keep it ranked at severity level 9, and 1 vote for upranking. And some highlights about this offense and what you all sent in. So as I said before, the most common response for this offense was to downrank it, and either downrank it from a 9 to an 8, or to create a new intermediate level between 8 and 9. And some of the reasons given for downranking included a feeling that this offense is not proportional to other severity level 9 offenses, and more specifically that other great bodily harm offenses are ranked at a lower severity level. Another reason cited for downranking this offense was the number of prosecutor agreed upon departures, which could signal that there might be more consensus than usual about this offense being ranked too high. There were also a lot of votes to keep this offense ranked as is at severity level 9. And some of the reasons given to do that included the fact that departure rates are below average. And there was also a comment about the level of harm should not be used to determine the severity level of the offense. And related to this was a comment that all first-degree assaults with great bodily harm should be ranked the same, yet aren't. There was 1 vote to uprank, and the rationale for doing this was that the offense is the intent to injure, and that the stat max cannot be reached at severity level 9. There were also a couple of legislative recommendations, including to increase the stat max and to redefine the mens rea for all assaults if the resulting harm is legislative intent for high max. So with that, I'm going to open it up to any questions or discussion about the ranking of this offense.
Does anyone have anything? Oh, Commissioner Director Wrights.
So I have a question about that legislative recommendation. Is the idea there that you'd be creating a crime where, because right now it's basically assault resulting in great bodily harm. Are you suggesting that there'd be another crime that would be assault where great bodily harm is intentionally inflicted, or that you change the elements of the existing crime, or how exactly would that work? That there'd be two separate crimes where great bodily harm resulted, but one where the great bodily harm is an intentional result? Or what was the idea of the legislative recommendation, I guess?
I'm gonna let the commission answer that, whoever maybe suggested that.
I don't know, Commissioner Fraze?
Thank you, Madam Chair. You know, this is an issue that cuts across a bunch of the offenses we were looking at. It's the central, sorry to, sound like a professor, but, I am. But it's a central problem in criminal law. How much depends on intent? How much depends on the actual harm, whether it was intended or not? And I think it's irrational, but it's Supreme Court precedent that the degree of assault depends on the harm, whether it was intended or not. And I think what you suggested, so I think that the standard answer to this problem would simply be to say the degree of assault depends on the degree of intended harm. Just so in this case, that would mean it's only a great bodily harm offense if you intended great bodily harm. But you suggested that you could kind of compromise and have another crime that's like the existing crime, but of lower severity, because we're not proving intent to cause great bodily harm. And that would be a reasonable package. But the simplest package would simply be to say, as we generally do with homicide crimes, you know, the degree of homicide depends on your mens rea, usually, except for felony murder.
Commissioner Larkin, did you have your?
My first question is on the comment, all first degree assaults with great bodily harm should be ranked the same, and yet they are not. Which are not?
Where is that?
I'm looking at this screen.
Oh, so it's like maybe
like-
the next. Might be on the next page.
Is it a table?
At the table, yeah.
Did you get an answer? No, but I'm letting the chair recognize.
I think it's hidden, so they're trying to find it for us so that we can see it.
Is this the correct table?
That's it. So it's the first line.
So what does it say? What does it say?
All first degree assaults with great bodily harm should be ranked the same, and yet they are not. Commissioner Middlebrook, so she can explain that.
Commissioner
Thank you.
Middlebrook? Yeah.
Yeah, so the other ones that are at severity level 8 are ones that result in great bodily harm, include labor trafficking, drug sales, child abuse, abuse or neglect of vulnerable adults that result in great bodily harm.
Oh,
So
okay.
Those are severity level 8s.
All the great bodily harm
Yeah.
type things. Okay.
And what's the statutory definition of great bodily harm? Is that significant probability of death?
That's one of the ways of getting to it. To find there was a paper I wrote on it. Yeah, it's either you lose a body part or you suffer a protracted loss or impairment of well, I shouldn't try to do it from memory, but so
I think it's the beginning.
So it's bodily injury that creates a high probability of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. So I would say the easiest way to get there is to knock out a tooth. That's technically permanently losing a bodily member. But then you could also put somebody in a coma for years. That would probably be the most extreme version of that, or blind somebody, or cause them to lose their limbs. Those are other pretty dramatic examples of great bodily harm.
And you had, Director Wrights had provided us with a paper sort of looking at offenses by harm level too. That was really, I found that to be really helpful in thinking through what I thought appropriate rankings might be here. So I think the point is well taken that they're not, there's one offense up higher and the rest are at severity level 8. Commissioner Middlebrook and then Commissioner Larkin.
Thank you, Madam Chair. Just one other thing that might be helpful to understand is that I think the reason this one is ranked so high and has such a high statutory max is that before the Supreme Court decision in State versus Fleck and then the appellate decision in State versus Dorn, the understanding was what Commissioner Fraze was talking about, that you looked at the mens rea, and those cases clarified that you look at the resulting harm. So the underlying offense is a misdemeanor assault, and then you look at the harm. So I think that the ranking for the guidelines is out of whack after, I mean, it doesn't make sense after those cases, because they stayed at that really high severity level. So they're just off.
Commissioner Larkin?
I don't understand that, because it seems to me if the case law says the mens rea doesn't matter, it's just that you intended to commit an assault, we look
Right.
at the gravity of the harm caused. Why are the guidelines out of whack? Why?
Right. Well, I guess in the sense that this assault one is at the severity level 9 and all the other ones are at severity level 8. I think that's why, because they ranked this one really high with a high statutory max, because the understanding was that you did look at the mens rea from the initial,
see.
and I mean, I think that's what the legislature ranked it, or did the statutory max at 20 years because of that. But, another recommendation would be to have the legislature do what Commissioner Fraze looked at. And if they're looking at the mens rea, they could create another crime with that as a higher severity level, if the intent is to assault and inflict the great bodily harm. I think that is what Commissioner Fraze is talking about too.
What if
Commissioner Larkin?
What if you intend to inflict great bodily harm, but you don't?
Attempt.
That would be an attempt.
Well, I mean, there's this little niche area of case law where appellate courts repeatedly say, like, well, yes, you shot the person in the chest, and reasonable people would look at that and say, well, that's a high probability of death. But the case law is very specific that you need sort of some medical evidence to say that really is a high probability of death. And there are plenty of cases that get reversed, because even though to lay people, that would seem like a high probability of death, it wasn't. On the other severity level 8 offenses, are those ones that we just ranked within the past couple of years?
Not all of them.
Not all of them. I mean, I do remember we had, in terms of human trafficking, we had some discussion about, well, does it matter? You're not really trying to do this. Here's the harm. I thought we kind of had those conversations at some point in the past year or two.
We did on labor trafficking, Madam Chair. Sorry.
That's good. Commissioner Ladd?
So I'm going to say this, and I'm going to try not to be redundant with every category that comes up, because I'm going to probably say the same thing. But one of the things that jumped out at me when I was looking at these things, and it was in our prior exercises with other re-rankings, is it seems to be, and I'll use the words from the survey, talking about the state of mind versus the result. And it's a little confusing to me that we're cherry picking some offenses that we want to look at state of mind, and other ones we're looking at the resulting harm or the conduct. And to me, I think if we're going to do this and we're going to equally rank these and give an analysis to all offenses, that we should be doing it the same. We shouldn't be looking at the state of mind or the mens rea over here and the resulting harm over here for certain offenses, because to me, I think we sort of are baking in some inequities in terms of how we're ranking them and at the severity level and the consequences that we're attributing to them. And that was kind of a common theme that I saw in this group. And in our prior exercises, those same kinds of discussions were happening. And I feel like we're not being consistent as we're examining this. So I put that out there for everyone's consideration, because that's a concern of mine.
Commissioner Larkin and then Commissioner Fraze.
Well, maybe, I can get behind that, but maybe then the level 8 should come up to 9. I mean, because this is some significant harm. And I mean, I don't know that it matters that you didn't intend to cause it. I mean, if you're causing this kind of harm, whether you caused it this way, with an intentional assault, or the way you treated people or contained people during human trafficking, why don't we just look at the harm and make them all a 9?
Commissioner Frace?
Well, I was one of the people that voted not to change it. And I guess, so two things. I mean, I do think we should recommend legislative mens rea reform here, but under the existing law, I think these other crimes, I wasn't on the commission when they were ranked, but I would guess, and practitioners, would have a much better sense of this than I do, that there aren't many cases of labor trafficking and so on where there's provable intent to cause great bodily harm, or even a really high substantial likelihood of causing great bodily harm, but it happened. So I guess to me, the typical case there is not as serious as the harm that actually happens in some of these cases. So therefore, presumptive sentence based on that sort of typical offense pattern. In this case, I mean, I even though I think the state ought to be proving intent to cause great bodily harm, in many of these cases they can't. They don't have to, but they could. And some of these cases, I'm pretty sure, would be attempted murder cases that may be bargained down to this offense. So, and when I look at these departure rates, what that suggests to me, and the prosecutors are often going along with it, is that when we've got a pretty strong case of intent to cause great bodily harm, this is where it belongs. If it's really accidental and all, then when we mitigate. So I think that's what the practice is telling us, which is why I said, don't change it except tell the legislature they ought to really fix the criminal law.
Commissioner Larkin?
And this is based on my memory. When we had the presentation, the summary regarding what practitioners thought, my recollection was, in talking to the prosecutors and defense attorneys, they said, there's a wide range of conduct. That's why you have these departures. But I recall that across the board, everybody said you should just leave things ranked the way they are because we find ways to go up and down when it's necessary. So I would speak in favor of not making any change.
Commissioner Castro?
Thank you. And I apologize, I'm new to the conversation, but as I'm listening, it would never be accidental, of course, because you always have to prove that the assault was intentional. And so in just thinking through it, it just seems to me that no change should be made until the legislature decides to reform, introduce legislation that does create a mens rea related to the level of harm.
Any other discussion on this one? Commissioner Mueller?
Thank you, Madam Chair. I, as always, appreciate the conversation from the practitioners in the legal realm because I learn every time someone speaks on this commission. So thank you for that. I'm looking at it from kind of the lens of, and this mens rea conversation is fascinating to me. We deal in law enforcement with just like the action and the result. And so, pointing a gun at someone's chest, it's fascinating that there's this, legal arguments to be made that isn't intentional, or someone could argue that they didn't intend for someone to die. I look at the result, and in labor trafficking, if someone piles 100 people in a car in the heat and tries to traffic them, no, their intent probably wasn't that they're going to die because they want the money from that, but the actions. And so we look at I'm in other cases that we've been ranking, I've been staying the same and even down ranking a couple in this group of offenses. I'm maybe the lone one, but I've actually looked to uprank these because I think it's the result, and that's what I'm looking at as the result is great bodily harm. And I have faith in the judicial system that you can mitigate, look at all the different reasons to take into consideration. These departures don't scare me a lot. They don't seem to be crazy that, oh my gosh, look at the number of departures or the percentage of departures that we have to change this. So I would be against downranking. I would be okay with keeping the same. And then I'd advocate obviously for upranking just based on the lens that I'm looking through. Thank you.
Thank you. All right, any other discussion on this one? right, hearing none, we'll go on to the next one.
All right, now that we've talked about assault 1, on to assault 2. There are 2 offenses in this group: dangerous weapon, assault 2 dangerous weapon, and then assault 2 dangerous weapon, substantial bodily harm. And just by looking at the graphs, you can see there's a bit of a difference between the way that, in general, the commission felt these offenses should be treated. With assault 2 having the majority of interest with no re-rank, and significant interest with legislative recommendations being made. And then assault 2, substantial bodily harm, significant interest in upranking. Some highlights, the first one's kind of just what I said, right? There's a general agreement that assault 2 and assault 2 substantial bodily harm should not be ranked at the same severity level. Some believe that these offenses should be treated differently depending on the type of weapon used while committing this offense, while others did not. Some suggested that assault 2 cases should be treated differently depending on the type of assault committed, such as causing fear, attempting to inflict bodily harm, and inflicting bodily harm. Additional note was that there were multiple comments about a legislative recommendation to remove or reconsider mandatory minimums in general. And then there was a cause for concern about the disparity in sentencing, specifically between a higher charge rate for white defendants, but then a higher incarceration rate for Black defendants. And so those are the highlights for assault 2 offenses.
So if I could kick off discussion, I'm actually really interested to hear what the commission thinks about this concept. Assault is defined in 3 different ways in the statute: causing fear, attempting to inflict harm, and actually inflicting harm. So I'm really curious how people see those things. And I think that also adds to the difficulty in our ranking offenses, right? Because not all of these offenses are equal based on some of those distinctions. And I don't have a particular view on it. I'm just actually really curious if anyone cares to comment on that and what you're dealing with in these types of cases. No, Commissioner Larkin?
I hate to ask the obvious question. Why is assault 2, infliction of substantial bodily harm, not ranked at 9 with first degree assault, infliction of substantial bodily harm? Am I misunderstanding that?
This is
Okay.
substantial, not great.
Not great. Okay.
So no takers on my question. What about other comments? Commissioner Mueller?
Not sure. Could you rephrase your question again? I'm intrigued
Well-
by the question, but I wasn't quite sure.
So what's baked into all of these assault cases is that there's another definition of assault itself, just the baseline action of assault, that I don't have the exact language up, but it can be causing fear of harm, attempting to inflict harm, or actually inflicting harm. And so they're kind of different in that way, but they're all under the same rubric.
So the language for the definition in the definition subdivision
Commissioner Ladd.
10 says an act done with intent to cause fear in another of immediate bodily harm or death. That's one.
Mhm.
Or the intentional, specific intent, infliction of or attempt to inflict bodily harm upon another. So it is lots of different things. And I think part of the problem, I'll just say in the family of assaults, is even if you look at a misdemeanor, you have the fear factor, or you have the attempt or the actual infliction, 3 different ways that you can get that misdemeanor. And the reason why that becomes important, I know we don't talk about misdemeanors here in commission land, but those are predicate offenses that are used to enhance to felonies as priors. So if you had, like, for example, 2 fear factor offenses, that gets you to that felony offense, that maybe isn't a fear one, it's an affliction, or it's an attempt. So I think if there's gonna be a legislative fix, it really is, that's a big one, because they've got to fix it in a lot of different places, and they've got to parse out those things, because for the purposes of using it to be enhanced, then that to me, that's like, is that enhanceable? If it's an underlying fear conviction, can I use that for only fear, conviction, enhanceability in the future? Or do I have to have an infliction one if I want to have a harm one to uprank it? Do you see what I'm saying?
Yeah.
So I think that your question is a good one, but because the language that the legislature sets forth in terms of how it defines it, there really are multiple ways of going about it. And the other thing is that you don't even have to use the attempt modifier in 609 and on the assault, because attempt is actually embedded in the actual language of the statute. So that's another piece that would also have to be looked at, because in a lot of offenses where there's an attempt, you have to use that modifier because attempt is not an element of the crime. Whereas in your assaults, it is.
And so you can still be convicted of a full-blown offense, even on attempt, and get the same sentence rather than the 50%.
Yeah, and that's why that's important,
Yeah.
because the modifier of the attempt trigger in the statute gives you half the sentence of the completed crime. But because the legislature put that in there as the element of the underlying crime, you don't need that modifier and they get the full sentence.
Commissioner Larkin.
Consistent with the theme. I mean, it doesn't make any sense to me conceptually to say that the presumptive sentence or the ranking is the same, whether there's only fear or there's actually substantial bodily harm. It seems like substantial bodily harm should be higher, which is presumably why we have such a high vote for upranking Matt.
Commissioner Keith.
So I guess just thinking about your question, the place that I'm coming at this from is thinking about the impact of harm on the victim. And I think often we will privilege physical violence over psychological violence, but often when it comes from like a healing perspective, it takes so much longer to heal from the psychological violence than it does the physical. And so I think that's just something that's coming to mind for me as I'm looking at that.
So assault fear may have this, what you're saying, I think is assault fear might have a longer lasting impact even than potentially somebody who received physical harm from the assault, or we can't know that basically, is what I think. We can't know what level of harm the person really experiences.
Yes, and I think I guess one of the, like thinking about it on a social level, if we were to parse them out and let's say causing fear was ranked lower, then what that also is saying to society is that psychological violence is like, it sends out messaging around what that actually means, and that we are making a determination about type of harm and volume of harm or impact to the victim, versus recognizing that it all might, like you might have 3 victims that have each had this, like causing fear, attempting to inflict bodily harm, and inflicting bodily harm, and the type of harm and how they're holding it, what that looks like long term for them might not be what we're assuming it is.
Commissioner Castro.
I just want to support the idea that assault to substantial bodily harm should be ranked higher for 2 reasons. First of all, the substantial bodily harm is essentially the same with an added element, right? So you have to prove the additional element of the substantial bodily harm. They both are assault with a dangerous weapon. And the statutory maximums for those crimes are different as well. One being 5 years and the other one being 10 years. So it would only make sense that the guideline that one would be the substantial bodily harm crime would be ranked higher than just the assault.
Did we ever get, forgive me if I'm just not remembering, but did we ever get information on the type of weapon that was used in these offenses? Or like gun versus not gun and that kind of thing?
Yes, it was in the.
It was in the packet, and I'm just not remembering.
Yep.
Okay.
Oh.
There were 3, I'm sure. There were three
Commissioner
things
Ladd.
that used a firearm, possessed a firearm, or other weapon. There were three categories from the 2014 to 2023 data. And for me, if I might just say, the reason why that also matters is because the mandatory minimums for the type of weapon is triggered differently depending on the weapon.
Mm-hmm, mm-hmm. Yeah. Yeah. I was also in the camp of ranking the substantial bodily harm higher than the other form of assault too, for the very reason that the Commissioner Castro just said as well. Any other comments, Commissioner Moore?
Madam Chair, I support the upranking of assault to substantial bodily harm for the reasons that have been articulated by others. I think there's a compelling reason to do that, substantial public safety concerns related to that. Regarding assault to dangerous weapon, the comment that Commissioner Ladd made, I think is important. The legislature has really bound district courts to a large degree regarding sentencing in this area. And I think one of my pitches was that we make a legislative recommendation to reconsider the question of mandatory minimum sentences for non-firearms offenses and maybe first offenses. I have no problem with the mandatory sentences for firearm assaults. I don't know. There's a lot of different variations in dangerous weapons other than firearms. And I would not differentiate between the types of assaults. I think attempting to do so raises the concerns expressed by our commissioner a moment ago regarding, kind of, I guess, giving qualitative assessments to the types of harm that exist. I think that's problematic, and I think that could introduce further complexity and disparities in the application of the guidelines, and more complexity isn't what we're trying to do here. So I guess I would be comfortable keeping assault to dangerous weapon where it is, with a legislative recommendation potentially regarding some of the mandatory minimum sentences.
Okay. Any other discussion? Commissioner Fraze?
Well, I think at least somebody else has already made this point, but I am very curious, not having been on the commission or paying attention enough, why these two crimes were not ranked differently, and why the additional element of actual substantial bodily harm did not result in a higher severity ranking. All I can figure is that for both of these crimes, I would guess we just have this problem of a wide scope crime. A lot of things can fall into that bucket and be charged in that bucket in different parts of the state, probably. All I can think is that the previous commission was thinking, not only are we not necessarily proving intent to cause substantial bodily harm, but there are all these different kinds of assaults, and the assault, so you have the combination of a very diverse assault definition, and then degrees of crime built on that without proof of mens rea as to the actual degree of harm. So, and I guess, again, when I look at these departure rates, I don't see now, I guess thanks to Blakely, we don't have very many aggravated durational or dispositional departures. The upward aggravated durational departure rates are very low, even for subsequent crimes. I guess there's not many of those cases. So anyway, that was why I said, first do no harm, don't change it. But, I appreciate the argument that there is substantial bodily harm in some of these cases, and harm matters. I mean, that's the dilemma for criminal law. Certainly to victims, harm matters whether it was intended or not, even though, we always repeat in criminal law, even a dog knows the difference between being stumbled over and being kicked. And maybe victims care about that. I don't know. Haven't had that experience.
All right, any other conversation on this one? All right, let's go ahead and move to the next one.
All right, so we're moving to assault 3, and there are 3 offenses in this group. A substantial bodily harm, a pattern of child abuse, and victim under 4. They are all currently ranked at severity level 4. For the substantial bodily harm, there seems to be the most votes to up rank, while for patterns of child abuse and victims under 4, the most common votes were to keep the severity levels as they currently are. So kind of highlights, again, substantial bodily harm had the most votes to up rank, and some reasons provided to up rank include the level of harm that this offense causes, the serious public safety risk, and how upranking this offense separates it from assault 5 and a domestic abuse / violation offenses. And then for assault 3, pattern of child abuse, and assault 3, victim under 4, most people said they wanted to keep the severity level as is. I do want to say that there were very few cases for both of these offenses. I think they're average 1 case per year for pattern of child abuse and 5 to 6 cases per year for victim under 4. So that's something to keep in mind. It was noted, though, for those 2 offenses that the vulnerability of the victim is a concern. So that was something noted. There were also a couple legislative recommendations. There was a recommendation to have case management resources to aid families in meeting basic needs and reducing overall stressors, and also to have some resources for parenting and classes and abuse prevention classes. In general, departure rates were cited as reasons for not re-ranking. This is overall assault 3 offenses. While the stat max, the pattern of behavior and seriousness of the offense were some reasons that were given to increase the severity level. So with that, I'll open up the floor to discussion.
Any discussion on this one? Commissioner Mueller?
I have a question, and I feel like it may have been answered before, maybe when we had the conversation. Maybe someone can explain this to me. And I know if, like, in a lot of these cases, the guidelines don't reach the stat max. And so I know a judge can, have an aggravated, upward departure on that. But why is it the case that someone explained to me, like, the guidelines for sentencing doesn't reach what the legislature has said would be the maximum sentence in any particular case?
Well, I'll comment that in general, the only grid that we have that does achieve that is the sex offender grid, and that was done intentionally. That was a redraft in the mid 2000s after that issue came to our attention. But in general, I think that the guidelines have looked at the stat max as an indicator of seriousness, but have always left room for the court to try to get there if they need to in an atypical case, but that's not been the driver for what the actual breakdown of sentences should be in each cell. And if somebody else has a better explanation than that, I'm happy to open it up. Commissioner Fraze?
Well, I just really build on what you just said. And when you look at guidelines around the country, most of them do what we do. Even for the highest criminal history category, it doesn't reach the statutory maximum, on the theory that within that category, there are typical cases, and then there are really aggravated offense cases for which we need to go higher and maybe even up to the statutory maximum. You wanting to leave room for aggravated offense facts and not have criminal history in that case eat up all of the statutory range. And so, the guidelines are based are a starting point based on a typical case, allowing for adjustments up and down.
Thank you. I appreciate I've had a hard time kind of digesting that a little bit. It does appear, we look to the legislature to give us guidance on I'm hearing today and a few legislative recommendations. Let's look to the legislature to help guide us on this. And they've given us in certain cases, a stat max of X, number of months, and with the, the maximum from history and a legitimate case can't even reach that. And I'm just trying to process that, and that's probably just not a practitioner in that realm. But as and when we work with victims and we say, harm matters, and they're trying to look, and I know the county attorney can probably speak to this and has to have these conversations many times to say, well, why the stat max is this, and we know the legislature has recommended this, and we can't even get there unless it's an atypical case. And so, just for the record, I felt the need to bring that up, and thank you for the conversation on that.
Commissioner Moore.
I voted to keep the second two where they were, but the assault 3 substantial bodily harm, I think there's a really good case for upranking that on the rationality question raised by the staff about, equating this with assault 5 or domestic assault or HRO, OFP violations with without the necessity of harm being proven, and underlying behavior is misdemeanor plus 2 qualifying domestic violence related offenses. It seems like assault 3 substantial bodily harm justifies a higher ranking than that. So I believe that should be upranked to the next level, 5.
All right. Any other discussion on this one? All right, we'll go ahead and move to the next one.
The next group was assault 4. This group, all the offenses were ranked at severity level 1. And the offenses in this group are assault against a peace officer, assault against a firefighter or EMS, assault against a correctional officer, prosecutor, judge, or probation officer, assault against a treatment facility member, or and assault motivated by bias. Severity level 1 is obviously the lowest level of ranking that the guidelines have. So you'll notice there are no votes for downranking. And there was a bit of a difference between assault against public safety officials versus the assault motivated by bias. Some highlights, like I said, there was a difference, and the main difference is that there's more interest in increasing the severity level of assault 4 offenses committed towards public safety officials and treatment providers rather than assault 4 motivated by bias. Those who preferred to increase the severity level of public safety official assault 4 offenses noted the seriousness of the offense, the threat to public safety, and the importance of protecting our public safety officials / providers. Interest in making a recommendation to the legislature to increase the statutory maximum for these offenses was stated. And some viewed assaults involving bodily fluids as less serious than other forms of assault 4, especially spitting, and preferred leaving this offense at severity level 1. Those who preferred to maintain the severity level for public safety official assault 4 offenses pointed towards the low departure rates, low stat max, and the infrequency of prosecution for some of these offenses. Additionally, those who prefer to maintain the severity level assault 4 motivated by bias wanted to do so because the offense is rarely prosecuted. Those interested in increasing the severity level of this offense wanted to do so because they assume this offense occurs more often than the number of cases that are prosecuted shows. But these cases are often pled to a different assault. And that raising the severity level of this offense might incentivize this offense to be charged more often and would allow interested parties to understand the motive behind the assault. Lastly, there was interest in having the legislature define demonstrable bodily harm. That I'd like to open up to discussion.
All right, comments on this one? Commissioner Moore.
I think this is an area where there's room for a legislative recommendation. I think the staff max on this is too low, frankly. And I think this is one where there could be a mandatory minimum sentence argument. But I thought this should be at a minimum upranked, but I think the stat max is going to preclude it from being ranked too much higher than it is currently. I think I was recommending it move to a 2, which isn't much, but it's something.
So I assume this would be charged if the elements of the higher level assaults weren't met. So if there wasn't substantial or great bodily harm, but that because of the nature of the individual who was assaulted, rather than a misdemeanor, it'd be this, right? That's how it's working?
That plus the bodily fluid.
And the,
portion of the statute, which I think might be the most serious concern in many of these cases, based on my experience.
Okay. Commissioner Castro.
So for clarification, assault for bias is a gross misdemeanor on your first offense, right? So we don't get here until you commit the same offense twice. Am I right about that?
Yes.
Folks in the room are saying yes.
Oh, okay. All right. And I don't know if that changes my mind one way or the other to move it up one to Justice Borst's point. Don't know that it makes much difference when you're looking at one or two based on the numbers. But the fact that it's an enhanceable, and the first offense has to be an assault, a bias assault. I guess I would lean that makes sense to increase the severity level.
You got three hands on that one. I'm going to go with Commissioner Ladd, then Middlebrook, then Larkin.
So just to sort of elongate on Commissioner Castro's comments, I think I would agree that it's somewhat inconsistent, because if you get a second one, the prior has to be within the last 5 years, and then the sentence is a year and a day, which is 2 days more than the underlying predicate one that's enhanceable. It doesn't seem to me that that's much of a consequence for a second offense. And so to have them be ranked the same, I think to have that ranked that way, it seems odd to have a 2-day difference in consequence for having that prior. Now, granted, the look back period is shorter. A lot of times those look back periods, are sometimes they're 3 years, depending on things, but 10 years, but the 5-year look back period is there. The other thing I just wanted to comment on, and I saw that in the comments here, that there was a suggestion that perhaps we parse out the saliva aspect of that. And I would just say I would oppose that, because in terms of that occurring and the risk to the persons that are engaged in that, I've had officers that have had to go through treatment as a result of having that saliva transfer, and they've had to go through some pretty long treatments to make sure that they were safe. Mm-hmm. And it only happened to them because they were performing their job. So I don't minimize that. And so I would not be in favor of sort of parsing out the type of bodily fluid or that sort of thing. So I want to put that out there, that I would not be agreeable to sort of looking at that differently than something else, because that is an enormous risk to the persons that are engaging with people in their public safety roles.
Commissioner Middlebrook.
Thank you, Madam Chair. I just, on the assault for motivated by bias, I just was looking at our packet. There is a statutory max of 1 year, so we're pretty limited by that unless it's a recommendation to the legislature. And also there's been no cases in 9 years. So that's, I don't know what the gross misdemeanor case numbers are, but there certainly hasn't been any felony cases.
Okay. Commissioner Larkin.
I agree with Commissioner Ladd regarding the saliva issue. It is an issue. It is a danger. And I agree with upranking them. I think a legislative recommendation is good to get the stat max increase, but I think in the meantime, we should also uprank just to show that we as a group think that it is more significant when you assault peace officers, firefighters, people who are attempting to help you in a treatment facility or in a probation capacity. I don't know that there's many in the public who would disagree with that. It seems reasonable. And I appreciate if we go up to 2, we don't get much. Could we go up to 3? I mean, you're just going to end up at the end of the line, but at least it recognizes what everybody seems to think, which is these are more serious offenses.
Does that create any stat max issues? I don't have that, I don't have the numbers in front of me, so.
Can Nate put up the grid real quick? Sure. Thank you, Nate.
And in the meantime, Commissioner Moran, go ahead and make your comment.
Yeah, yeah, I just, figured I should touch base. When looking through these and going through them and just seeing the minimal jump between the severity levels, it didn't, and it's just re-echoing what everyone's saying, but it honestly felt like it was very minimal. And many times there's so many cases on a day-to-day basis that do not get reported. And I said this in my comments, but, if we feel it's in need of being reported, it's obviously pretty bad. And so when you see such a minimal incline between the two, it's just doesn't seem like much. Obviously a little biased in the situation, but I was hoping for a little more of a jump in the severity level.
So,
And then why don't you go ahead and put that up and then we'll take comment from Commissioner Keefe.
I do have sort of an answer back on the secondary assault question.
Oh, can you answer this one first? Let's stick here for a while. So I don't remember what the stat maxes were on these assault fours. We know that one of them was a year, so going up to 2 or 3 could be problematic. I don't know what they were on the others though.
It doesn't
You have
fit
a
well
stat
on the
max?
grid. The commission did just,
Peace officers, it's 3 and the other 2. 2 years ago.
Yeah, well, they go up to 2 and 3, so for peace officers and,
Firefighters, emergency personnel, correctional,
yeah.
prosecutors, judges, probation officers.
So it seems like the one is the exception. Everybody else does go higher, so you could go up to 3. I mean, you could go up to 4.
Madam Chair, that's right. When I look at this, I see 4 as a completely,
Yeah.
if we're talking about increasing that and trying to get to that top of the box, and that to me is 4 is where that would lie with the stat max of 3 years.
Let me get the comment from Commissioner Keefe.
Yeah. So, like, speaking specifically about assault 4 motivated by bias, I just wanted to name, I also suggested upranking to 3, also in part because of assaults that are motivated by folks like based off of race, ethnicity, religion, gender orientation, gender identity, things like that. And also noted that those types of things occur often, but don't end up getting charged or get downranked, or get pled down to different types of crimes. And just wanted to name that. I think that's the other population that I'm also thinking about.
Okay. So if we took everything to 3, I assume we'd need a legislative recommendation to increase bias, the stat max on bias.
Well, also, Madam Chair, also on firefighters and EMS personnel too, that's 2 years, right?
That's what I didn't hear. So some of them are 2 years and some are 3.
Right. So we could just do them differently based on the current stat maxes. Put the 2-year stat maxes at 3 and the 3-year stat max at 4.
Commissioner Ladd.
Thank you. So as some of you know, part of my exercise in all of this was I took a look at the whole guidelines to know and to look at other offenses within rankings. And because to me that matters too. So if you look at other current offenses that are like at 3 right now, gambling taxes, insurance tax, possession of burglary tools. Again, trying to have some rationality of those things, it doesn't make sense. Now I recognize like if this got bumped up to a 4, we're talking about those domestic assaults. We haven't gotten there yet, but I think that's underranked. So I think that's part of the problem. And I think I've highlighted this in my prior discussions is that we can't look at one without looking at others because the rationality of how other things are ranked when we look at them it matters. And I will tell you, sitting down and talking with victims about these things, when I'm showing them guidelines and I'm showing them where they fall in the guidelines, and they're like, how is that less than, for example, somebody who has a charge for insurance tax or gambling tax? I mean, it doesn't make sense, and it doesn't make sense to me. But again, I think that's what we have to look at too. It's like, what other kind of offenses are in that same bucket severity level? Because I think that kind of lends itself to some rationality as to what we're doing and why we're doing it as well. So I just wanted to put that out there.
Yeah, one of the comments that I had made on this one was, I think for all of it, it's demonstrable bodily harm. And so that also came into play for me. There is no definition of what that means. But some of the other types of assaults that are ranked then higher have presumably higher levels of harm as well. So I was also thinking about proportionality in terms of the type of harm, not only who was harmed, but the type of harm. So I think it does come into play. What are we doing at severity level 4? Because we have some also serious crimes there as well. But so I think number one, if we did any legislative recommendation, we should be asking for a definition of demonstrable harm as well.
Do we not have that in case law?
I was just going to say, I feel like, and
Is
I
it
was
in
going to
case law?
refer to my judicial friends.
No, it's
I
good.
feel like that is defined in case law, and that's where we
Oh,
end
in a
up
minute.
going to look at that, because in the statute itself, it isn't defined.
It's
And
not
so,
there, yeah.
Yeah, so I feel like if we're going to ask for that legislative fix, we should also be looking at what the case law is saying on that, and perhaps that's how it gets fixed. I don't
Right.
know. I'm sorry, I didn't mean to jump in on you.
No,
I
that's
apologize.
perfect. That's like, I wasn't going to do a case law search.
I thought maybe my judicial friends would just say they would know.
I'm looking it up.
But that makes it easier to request a definition in statute, though.
There's a case that says it's not error to define it as bodily harm capable of being perceived by a person other than the victim.
All right, any other discussion on assault 4?
Just a reaction
Larkin?
to Commissioner Ladd's point about, what's at 3. I mean, what that says to me is like all the more reason to uprank these.
It's an interesting list when you look at them as a whole, and I just would encourage everyone to do that. I think that's helpful.
All right. Okay, thank you. So we'll go ahead and move on to the next group.
All right, so assault 5, this is our last assault offense. There's only one offense in this category, and it is assault 5, third or subsequent violation, and it's currently ranked at severity level 4. Most votes were to keep this as is, ranked at severity 4. There were multiple comments raising concerns about having assault 3 offenses ranked at the same level, severity level as assault 5. One solution mentioned would be to increase the severity level of assault 3 offenses. There was some interest in providing different severity levels depending on the type of assault committed, but then others thought that this would add complexity and confusion to the guidelines. Those who were interested in increasing the severity level of this offense mentioned the stat max as a reason for doing so. And those who were interested in lowering the severity level pointed out high durational departure rates. And there was some curiosity about the high durational departure rates and the offense being committed against the same victim multiple times. And then there were also a couple of comments for legislative recommendations to make the distinctions again between fear, attempted bodily harm, and actual physical harm. So that is it for assault 5. Open up for discussion.
Commissioner Moran.
I apologize. I bumped that. Didn't mean to hit that.
Oh, I thought you were ready to jump in on this one. Okay, Commissioner Mazzaros.
So I made the recommendation for the distinction between fear, attempt, and actual physical harm. Unfortunately, I've interacted with individuals that have gone ahead and punched their significant other or committed because they knew that their charge, the cops were coming and their charge was going to be the same if they did it or not. So they went ahead and caused physical harm, knowing that about the law. And so that to me is significant. So intent or whatever else, but when that physical harm comes, that to me elevates it to another level, and it should be treated that way.
Other comments? Commissioner Fraze.
I was one of the two people that suggested lowering the severity level, and I guess at least I also distinguished between the same victim, any victim cases. I'm curious to know how it breaks down in the actual cases that are sentenced, because I would predict, or at least it would seem plausible, that judges with often 80% prosecutorial approval would downward depart durationally in the any victim cases, because then there's a problem of double counting prior record. In the same victim cases, prior record doesn't take that into account. So you could say there's an additional aggravating factor, not just that you have prior qualified assaults, but you did it against the same victim. But in any victim case, it's just kind of double counting criminal history. So I guess I look at the high mitigated durational departure rate, higher prosecutorial approval rate. I wonder if most of those are any victim cases in which if there's a thought that we're double counting prior record.
Interesting. Commissioner Keefe and then Commissioner Ladd.
Yeah, I actually had a really hard time with these. And even now, as I'm looking at how I ranked them, I think I would shift. But I, was talking with a prosecutor in Hennepin County, and they were sharing that from what they have seen, it takes an average of 7 charges before somebody actually sees jail time for a lot of domestic related crimes. I'm sure there's a lot of nuance to their comment, and so just to name that, but I think for a lot of these rankings, I said that I would not re-rank, and I would actually up-rank, given some of the conversation that I've had with prosecutors more recently. And I do think thinking about pattern of violence, whether it's the same victim or a different victim, or if it's multiple victims in the same type of crime over time, are also things to look at.
Thank you, Commissioner Ladd.
So just, I think part of the conversation about this, to kind of piggyback on Professor Fraze's query about like, how does this break down? So first of all, this is not a domestic felony assault. This is a 5th degree assault with a non-domestic partner, but it is with the same victim, and the look back period is 10 years for any qualified prior domestic violence related conviction. So so the current victim is not that, but look back's 10 years. But if it's not the same victim, the look back is only 3 years. So that's another interesting piece to this, that the look back period for the 2 different offenses for a felony 5th degree assault, depending on who the victim is, the look back period is either 10 or 3 years. And so I don't know if that helps answer the question as to sort of who the victim is, because if it's the same victim, the look back period is a longer period of time versus that 3-year period of time. So that's a nuance that's baked into the statute as well that matters, I think, as well.
Any other discussion on this one? Okay, I think we'll go ahead and close the discussion on that. I think that's the last straight up assault, and we move on to domestic assault.
Yep, that's right. So we separated these domestic assault offenses. We separated domestic assault offenses with violation offenses. So first we'll talk about the domestic assault offenses, which are currently ranked at severity level 4. This includes domestic assault and then domestic assault strangulation. And as you can see by this figure, domestic assault strangulation had a bit more interest in upranking and was perceived as a bit more severe. Like I said in the first bullet already. So second bullet, those interested in maintaining the severity level of domestic assault had interest in increasing the severity level of assault 3 offenses to address the disproportionality in ranking between these offenses. This is something that's already been discussed here today. For domestic assault, there was interest in distinguishing between the types of assault, so similar to some other assault offenses we've already talked about, but especially in this offense category, others disagreed that on the grounds that actions that inflict fear are just as detrimental. Another comment we've already heard today. Last, the lethality element of domestic assault strangulation was pointed to as the reason to increase the severity level for that offense. And with that, I'd like to open it up to conversation.
All right. Discussion from the commission members. Well, I'll say that I think I was in the camp of increasing ranking on this offense, and I was influenced by a previous discussion that we had here at the commission, where I really thought about the fact that how many times domestic assault has to occur before it might result in a prison sentence where it was currently ranked. So given that this is a repeat offense just to get to the felony level, I was persuaded that I think it needs to move higher. So that was what I was thinking when I was looking at this offense. Commissioner Moran.
I'm actually here this time. Yeah, I mean, for that one, I echo that, for the domestic assault, especially with the strangulation, for somebody that's responded to many calls where the deal with this sort of situation is, strangulation takes it to a whole nother level. When we talk about mechanism of injury and different forms of assault, and assault with strangulation is very personal, and it is very, it just takes it to a different notch in my book, and takes it up a level. So for that reason, I feel like it needed to be upranked, especially in that domestic assault aspect.
I think I saw Commissioner Keefe's hand.
Yeah. I will eventually figure out where my comments should go. So I'll say everything I said before applies to actually this grouping. And also just wanted to highlight the strangulation as well, that often that is a risk factor for lethality. And so I think upranking that would be valuable. And just to note that like domestics and domestic homicide, all of that is happening more frequently. And so thinking about how sentencing can be a deterrent for that, and feeling like I did say not to re-rank, but I really am thinking that ranking them higher would be good, while also looking at legislative recommendations around treatment for folks that use violence and restorative options for victims and folks that use violence.
Can you say more about the legislative recommendations? Aren't there minimum treatment requirements in the law right now?
Yes,
I can't remember.
They're outdated, and actually the Department of Corrections is looking at updating them right now. And there's issues around like resources to actually follow through with that in a way that is effective. And so I would say legislative changes around like what resourcing looks like and also what goes into treatment modality. So as an example, it's about 6 months of treatment for somebody who's using violence, but there isn't resources around the ecosystem that the person is a part of. And so really looking at what recidivism rates are and what leads to successful outcomes and what more is required, which I can go down a black hole about this, so I will stop right there. But I have lots of thoughts about what would be more helpful in community when it comes to supporting victims and folks that use violence around shifting behavior. But don't want incarceration to be the only option. Yeah, really want to encourage both.
I think you're triggering for me that the issue is it's a rigid one size fits all treatment requirement, and it's not necessarily tailored to what the person, what might be most effective.
Yes.
Commissioner Ladd.
Thank you. So I'm one of the uprankers on this one, full disclosure, and I think I'm the one that sort of brought the issue about sort of how do we get to felony land on these domestic assaults with having to have the 2 prior convictions within 10 years. And one of the things related to what Commissioner Keith just said is that there are these requirements to take the domestic violence programming and be subject to probation. And the fact that they're required to do that as part of a probationary requirement, and we still get to having those priors, community-based services have failed, and we still get to a place where the violence is occurring, which is creating risk. And yet, even when we get to felony land, it is not even yet where we're looking at a prison sentence. It's still a presumed stay, and again, more services. And I just think when you also look at, in combination of all of that, and you look at what other kind of offenses are at severity level 5, it makes no sense to me that this is a severity level 4 offense. We have bribery, price fixing, interference with an emergency communication, emergency call interference. I don't know how those things are on par with a repeat domestic violence offender. And so for me, it makes no sense for it to remain at a 4. And that's why I feel like it should be ranked at severity level 5.
Commissioner Mueller.
Back to the stat max. So we have it ranked at, maximum is, months on our guidelines. And again, I understand their guidelines is, it's under that 30 with a 6 criminal history score. And so I think there is room for, as directed by the legislature even, to move this up. Thank you.
So I just want to call this out because I'm seeing a lot of no re-ranking on the stats here, but I'm hearing more re-ranking, more desire for re-ranking. So is this like people have reconsidered and are interested in that, or is it a split?
Are we we're only talking about the domestic assault. We haven't gotten to the strangulation one yet, correct?
I think, we're on these 2 right now, I think.
So we're talking about both of them?
Yeah.
Okay, then I do have a comment.
Yeah, go for it.
So I am very passionate about the domestic assault strangulation being way too low in terms of ranking. And I do think that needs a legislative fix. A 3-year stat max on that is unbelievable. But for the completion of that crime, which would be a homicide, you don't get closer to that than strangling somebody and choking somebody out. And the idea that it's ranked the way it is and it has the stat max the way it is, I just think that's a problem. And I think we need to rank it higher, and the legislature needs to fix the stat max on that.
And I just want to say yes, yes, yes to everything that the commissioner just said.
And I'll just say I support those comments as well.
Thanks, Commissioner Castro. All right, so I think I'm hearing, I think for this one, I am hearing something different than what's showing on the slides. Okay. All right, so that's good. Why don't we move on to the next one?
Madam Chair.
Yeah.
Before we leave assaults, would you like me to talk a little bit about the history of second-degree assault rankings?
Oh, I'm sorry. I forgot to get back to you on that. Yeah, go
No
for
no
it.
problem. So it's,
Yeah.
it's not very much history. It was basically a 4.5 hour meeting in 1992, May of 1992, and there's just very little discussion about it. But basically, they acknowledged that the legislature had made this new species of second degree assault, and the commission decided to keep it ranked at the same. So I don't know what the breakdown was or whether there was any dissent, but it's basically one paragraph in the minutes. That's all I have. At that time, in 1992, there was no severity level 7. So that may have been the difference, is that the only option they had at that time was to go above the dispositional line, which the commission now has an intermediate option that was not available to the 1992 commission.
What was this first one and which one, what form of assault 2 was original and what form came in to play in 92?
The 10-year stat max with substantial bodily harm
Okay.
species was added in 1992.
So it was originally the assault with a dangerous weapon was the original form of that, and then they added substantial bodily harm. Okay.
Madam Chair?
Yeah.
This is probably way too far in the weeds for this, but so was there also a mandatory minimum at that time too, when there wasn't that severity level?
I don't know that.
Okay.
All right, thank you. Thanks for that. That's interesting. I think, so we're now into protective order violations.
We are, and we just have 2 groups left, so hang in there, everyone. This is offenses related to protective order violations, and they include violating domestic abuse no contact order, violating orders for protection, and violating harassment restraining orders. And as you'll see here, there's pretty much a split between keeping them as they are and downranking. And the current severity level is 4 on these offenses. Go to the next slide. Yeah, so there was a recognizable split between interest in keeping these offenses ranked at severity level 4 and then decreasing the severity level to a lower level. Reasons given to downrank included high dispositional departure rates, and that these offenses are not as severe as assault 3 offenses and domestic offenses. There was also a comment to only downrank those violations that did not involve a firearm. And there was a comment about increasing concerns about compliance with court orders, which is actually an argument made against downranking these offenses. There are some concerns about proportionality between these offenses and assault 3 offenses. One suggestion is to address the issue by increasing the severity level for assault 3 offenses. And there were also a few comments about possible legislative recommendations. One recommendation included adding case management services to domestic violence resources to help families addressing basic needs as a way to mitigate violations due to social economic factors. And another comment was to have a shorter time frame for counting priors. So with that, open the floor for discussion.
All right, comments? Commissioner Moore.
This might sound a little self-serving, but I don't think this is a time where we should be downranking offenses if people are intentionally violating court orders and in some cases causing harm to people. I just don't think that's a message that's appropriate. And I was one that was in the camp of addressing any disparities with assault 3 by upranking assault 3. I realize there's a lot of different variations in behavior that get people charged with these offenses. And I think that those are best dealt with on a case-by-case basis. I think the lawyers and judges are addressing those more arguable technical violations in cases that they should be addressed. But I was in the camp of not changing the ranking on this one.
Commissioner Ladd.
Thank you. Well, I was sort of on the fence. I was definitely not in favor of lowering it. And I was a little confused about some of the comments when I was reading through here, because the statute for these protective orders already addresses if somebody violates the order and they have a weapon. There's a provision of the statute that gets charged. Otherwise, you have to have the 2 predicate convictions on your record to get charged with felony. So there's 2 different provisions of the statute. So the weapon piece is already baked into that in terms of if that's a violation, it has different elements, I guess that's what I'm trying to say. The other thing is that why I think at least it needs to stay where it's at, is that this is really our only proactive sort of law that we have on the books, because two of these, the HRO and the OFP come as a result of a civil proceeding where a court makes findings and makes a determination about harm, risk, all of that. And it's only a violation of the law after that hearing occurs if somebody violates that protective order. Now, the DANKO comes as a result of a criminal proceeding, but again, the court has to make independent findings about the appropriateness of that order. And it's not a violation unless the person violates it after the fact. And those protective orders are put out there, so in theory, to be proactively protecting people. And so I feel like we shouldn't disregard that and downplay that, because at the end of the day, we recognize those protective orders are only pieces of paper, but we expect people to follow them because of the risk that's involved. And so at a minimum, it should stay the same. If not, be moved up one, but I'm on the fence with that, but I don't think it should be downgraded.
Commissioner Mueller.
I just echo the comments that have been said, and I appreciate that. This is a part of, at least in the criminal justice system, something that has evolved over my, 27-year career. And it's, there's victims here, real victims that are truly scared, and the judge and findings, whether civil or, as a result of a crime, are putting these orders in place. And I have found prosecutors and judges to have common sense. If this is, there's comments on sharing a car, and, if these are individuals that are, parenting or doing whatever, that they've been able to navigate those on a case-by-case basis. But what we're saying is, and when we, push for, to violate people, take them into custody on these, it's a precursor to, stalking and homicide. And we're seeing this moving forward. And so I think this is a step, just like lethality assessments on domestic arrests and different things, that we're stepping in and being, as is mentioned, proactive. So I would really, really hate to, a step back would be really, I think, to not take victims into consideration.
Commissioner Keefe.
Yeah, just to echo and support all of the comments that have been made already. And I voted to uprank. I do think that it's, someone started out the conversation by saying that it wouldn't serve community right now to lower it with what's happening. And so I would be really strongly against lowering and downranking it. I think the comment that I made was, there's definitely folks that violate with intention, and it absolutely is a lethality factor. And there's also the subset of community where maybe they have one car and they have childcare needs and they have employment needs. And so the violation happens purely out of necessity. And having those other case management type resources can really help with reducing violations when it comes to socioeconomic needs, employment needs, childcare needs, things like that.
Thank you. Are there any other comments? Commissioner Moran.
Yeah, I just wanted to reiterate what Commissioner Mueller said about having the discussions and how important they are. Some of this discussion, especially what Commissioner Moore had said, I believe it was Commissioner Moore that spoke up for first, kind of echoed and changed my thinking a little bit. A lot of these, the really only one of them, which would be the center one, was the only one that I chose to downward rank. I'd probably change my decision at this point, just because it was, thinking on case-by-case basis and allowing the judges to do their job. So I appreciate the feedback, and I'm just grateful for this discussion.
Thank you. All right, any other comments? Commissioner or Director Wrights.
Yeah, I just wanted to point out, this is the violation of the DANKO is the most, we've been talking about a lot of severity level 4 offenses. the violation of the Danco is the most common severity level 4 offense in Minnesota. And about 3% of the prisoners in the state are violation of Danco prisoners. So, you know, and that's obviously heavily influenced by the severity level ranking.
Oh, I didn't know that about the prison. All right, any other discussions here?
I just, one question.
Commissioner Mazzaros.
Is that due to the fact that the Danco is probably the most commonly issued?
Well, I can't say it's the most commonly issued, but it doesn't, unlike the other two where the victim has to initiate something, or the prospective victim has to initiate something, the Danco is initiated by the judge. It does not require as I recall, the victim's consent at all. The victim doesn't have to participate in the process, and so I don't have statistics for this. Perhaps Commissioner Keefe does, but I mean, Commissioner Keefe already alluded to this, where you can have circumstances where you kind of need to be able to get together just to sort of do your common life, but there you are in violation of the Danco. So it's,
I think oftentimes though, they don't take the proper procedures to make them car exchanges and child exchanges and all that stuff through the proper channels, and then violations occur probably more often than not versus the other ones where they are victim initiated.
yeah, I mean, it's an interesting offense because it's the newest offense that we've been talking about, and it's really it really has sort of taken off in popularity.
I
Commissioner
don't.
Phrase. Oh, sorry, go ahead. Commissioner Keefe and then Commissioner Phrase.
Sorry. Thank you. I just was going to say I don't have stats, although I could get some if the commission wants to look at that. But I will say anecdotally from talking with victims, it is complicated because some victims appreciate having the judge make the call because it provides them a layer of protection and safety because it's not something that they drove. And for others, especially when there's these other types of needs, it does make it really difficult. And when it comes to even like a chosen order for protection, because of those other struggles and challenges being in place, it's often why victims might drop an order for protection because they have to choose between childcare for their children or their own safety. I also think that with the Danco violations and incarceration, like it would be really interesting to know what type of violation it was. If it's, again, like if it's because of a socioeconomic status issue, or if it's because there was this really intentional violation, and how many of those folks are part of that 3%, like what the breakdown is for that 3% incarceration rate.
Commissioner Phrase.
Well, I guess I was initially going to comment on Director Wright's observation about the volume of Dancos and wondering, but this is a question that applies to the next two, OFP and HRO as well. I'd be curious about the breakdown between the two kinds of violations, the one based on previous convictions in 10 years and the one based on possessing a dangerous weapon, which might, intersect also with some of these other case-specific facts about what was going on with the couple, or the two people at the time. But I guess I would, this, I guess, anticipates a broader discussion about prior record, but 10 years is, a lot can happen in 10 years. Dangerous weapon is a dangerous weapon.
Do we have a way to break that down, Commissioner or Director Wrights?
Is that in the database actually, that you would be able to break it down as how many are of which subdivision? I guess it's in the statute. Right?
It's a different statute.
I don't know. You know, do you-
Perhaps.
no. We can, and maybe one other point, Madam Chair, if I may.
Yes.
Is worth noting here, and then sort of the corollary to say that Danko is the most common severity level 4 offense. It's undoubtedly also true that Danko is the most common qualified domestic violence related offense. So when you're talking about all these offenses, that if you have a multitude of domestic violence related offenses, you're looking at a felony for committing these crimes. It's probably a good bet that Danko's in the mix compared to some of these other qualified domestic violence related offenses.
All right, any other comments or questions or discussion before we wrap this? Oh, wait, we have one more group, aggravated robbery. Right.
That's correct.
All right, let's go ahead and move on to that.
Great. So the last group is aggravated robbery 1. Current severity level is 8. And as you can see by this figure, the majority of interest was in not re-ranking this offense. Many noted that the racial and age demographics of this offense are notable, but most believed they should not be used in consideration for the ranking decision for this offense. Also, some suggestions for this offense included eliminating the mandatory minimum for first-time offenses, creating a border box for severity level 8, criminal history score 0 offenses, and considering re-ranking the offense differently depending on the type of robbery. So robbery with a gun versus robbery with a knife, et cetera, et cetera.
All right, any comments here?
I think this is the one where we were told, boy, there's a wide range,
Yeah.
but it's appropriately ranked and courts are figuring out what to do within that ranking.
All right. All right, not seeing any other comments, so we will go ahead and wrap this up. Thanks again to our staff for putting together this summary and giving us all the information to have this discussion today. It was a really good discussion. All right, so that wraps up the ranking portion of our agenda today. I'm going to move on to talking about the August 13th meeting because I want everyone to be ready for it. So a couple of things that I really want to talk about. No, Nate, you're going to have to remind me, did we ever set a time for that meeting?
That's 10 to 4.
10 to 4, okay. So the meeting time is 10 a.m. to 4 p.m. It's a long one. It is going to be the first time the commission will get a proposed package of changes for us to talk through this fall. This will be your first look. And so there's going to be a couple of different elements to it. I'll talk about those in a minute, but I really do think this is a meeting where it's going to be important to be in person. So my request is that everybody come to this meeting in person. We will only have online available for emergencies. So I am asking everyone to be here in person, and we're going to be here at DOC again.
In this room.
Okay.
Yep.
So a couple of things that here's what's going to happen. So I didn't think to put the the proposed method that we came up with for doing this comprehensive review back in front of you today. But if you recall, we have been taking a couple of different tracks over the past 6 months. Number one, we do have a steering committee that has been sort of prepping some materials for the commission to consider. So the steering committee is the one that identified which areas, which offenses we were going to go through this ranking exercise with. So that, once the steering committee sort of narrowed in on which offenses we were going to tackle this year, those got forwarded to the commission, and then that's the work the commission has been doing in each of these packets. So you are going to see those rankings put back in front of you, but we're going to narrow it down to the areas where through this discussion, it feels like we might have some agreement on items to be re-ranked one way or the other. And you can disagree with those. So do your homework. You'll be getting all this ahead of time. And if there's something that didn't make the list that you think really should have, like that will be one of the days to talk about it. So you'll see those. You'll also see a package from the steering committee of other substantive changes we've been working on, criminal history and, you know, other topics along those lines. So that'll be our opportunity to present new ideas to you that you haven't heard before. So we're going to be talking through those. Prior to going through any of that, we are going to get the last pieces of research that we've been asking for, because that's also the third track that has been happening is we have a team of researchers at the U of M who've been doing some research alongside us along the way. So we're actually going to get two pieces. We're going to get from our MAD consultants, we're going to get a presentation of their stakeholder input. So we're going to get to hear all of that one more time so that we can reground ourselves in some of the input that really set the tone for this whole comprehensive review. Then we're also going to hear from Dr. Leskarensky at the University of Minnesota, who's been doing interviews about these offenses with high departure rates. And we want to do that up front because that may affect your feelings about some of the ranking decisions that we've talked about today too, or today and over the past couple of months. And then we'll have those ranking decisions and steering committee pieces in front of you. And we will be, you know, I'm still going to be working with staff between now and then to sort of figure out the process for how we'll go through that. But I want to be really clear that August is first look time. No decisions will be made in August. August is first look. I want you to, you know, scrutinize the materials. I want you to come prepared to talk about them and get your ideas on the table. Like, does this look right? Does it look wrong? Are we missing something? Where should we be going with this? Did we miss a whole category of something that should have been on the table for discussion that we never put there? Do you have tweaks or recommendations for how we should be sort of changing up the ideas? That's what August is about, discussion. Let's get some discussion on the table about these ideas that have been put in front of you. There's not going to be any bed impact in August because what we're working towards is developing a package that we think is a good set of policies. And when we get narrowed in on a package, then we'll get the bed impact for the whole package from our staff. So that's going to happen after the policy work. And we're also I'm challenging our staff to think about not only numbers of beds, but are they the right kinds of beds? We've talked a lot over the last year about, you know, ensuring that repeat violent offenders have prison sentences, that low-level offenders have probation sentences. So when we do some of these changes, is the mix in the right direction? Are we actually reserving prison for the ones who should have prison? Or are we messing things up, you know, unintentionally, right? So we want to try to figure that out too. So that's going to be not an August conversation, but that will be a future conversation. So the idea is that we're going to do all that discussion and we're going to hash it out. And we will keep bringing it back over the next couple of months. So the way this fall is going to go is that there's going to be a lot of attention paid to this package and developing it and refining it and getting it to where we want it to be. We do have to make a final decision by November on what the package is in order to have a public hearing in December so that we can move anything forward to the legislature in January. So that's kind of how August is intended to go and how the rest of the fall will go. Did I miss anything, Nate?
Just for those who aren't aware, the commission does have a first reading rule. So November may be the deadline for final final policy proposals, but October is really the deadline for new policy proposals because it has to be discussed at two different meetings before the commission can take action on it. The other thing is simply that lunch will be provided. So it will be, don't plan on making, lunch hour plans. It's very much going to be it's only going to be 6 hours of work, but it's going to be pretty solid 6 hours. So,
And our staff's going to be really tired because they will have been at the NAS conference the 2 days before that. So,
With a road trip.
right, exactly. Any questions about what August is supposed to look like and how we plan to proceed?
I have a question.
Commissioner Castro.
When you say that you're putting together this packet, are you asking us to put forward any types of things that we think should be discussed?
Not at this time. You will receive this in advance of the meeting, like always. We normally, will it still be a week earlier? Is that what did we decide? Okay. So we're trying to get it out earlier than a week early. So you'll have some time to look at it. And what I'm really asking is come prepared with, is there something that might be missing that you really think that we should have taken up? So the steering committee has honed in on, has already vetted some ideas, and I'll try to come up with a way to make sure that you know what those are as well. But there might be something that we're missing as you look at that package and you're realizing it's not quite lining up. Commissioner Larkin has a thing to add here
Just
too.
a comment, this ranking exercise, we've done several of these, and I think there were a handful of offenses for which there was, I think, consensus. For example, criminal vehicular operation. I think there was agreement to raise the ranking on that offense. Were there others? Just so I feel bad someone coming into this at this point. It's like, what have you guys been up to? Are there any other major ones? But CVO was the one where everybody said. CVH and CVO, yeah. Anything else that comes to anybody's mind?
I can't remember what they are. There were a few others. Yeah.
You know what? One of the ones that I've always been concerned about, and I don't know if you talked about this recently, is fleeing a peace officer. You have great bodily harm at severity level 6 for fleeing a peace officer, and that doesn't make sense to me. So I just thought I'd put it out there. Those are getting worse and worse and worse.
You know what, one thing you're reminding me, Commissioner Castro, is I'm going to ask the staff to make sure that Commissioner Castro receives the prior ranking packets so that he can see how the commission came out on some of those discussions too.
Does anybody remember how we came out on that one?
All over the board, I think.
All over.
All right. Any other questions, comments? All right. Okay, so I think that's enough for the August 13th meeting. I know that Nate has the executive director's report, so we'll turn it over to him.
I'll be very brief, Madam Chair. It's just, we have sent out our invitations for NASC, and we're taking Commissioners Keefe, Mazzaros, and Moore to NASC. That's the National Association of Sentencing Commissions Conference. I know that Commissioner Middlebrook and yourself, Madam Chair, are going funded by your own agencies. So we'll have a pretty good showing there. It's in Madison, Wisconsin, and it'll be the 2 days immediately prior to this. And so we'll be getting back in the evening of the 12th and then showing up bright-eyed in the morning on the 13th with all kinds of really neat and creative ideas about sentencing going through our heads, no doubt.
That's true. Anything else on that, or was that the total?
Yeah, that's really it for my report. Thank you, Madam Chair.
Okay, great. All right, last item is the public input.
All right, members of the public online, if you would like to make a comment at this time, would you, looks like you're all on with some kind of electronic device that should allow you to raise your hand. So if you press the button on your app or however you're viewing this meeting to raise your hand at this time. We'll unmute you and you'll be able to make a comment to the commission if you'd like. Also, that same goes to any members of the public in the room. If you'd like to make a comment, just please stand up and the chair will recognize you. Madam Chair, I'm not seeing anybody online or in the room indicating that they would like to make a comment to the commission.
And I concur. I'm not seeing that either. All right, so that brings us to the end of our meeting. So hey, for the first time in a long time, I'm letting you out early. Yeah, exactly. We'll pay back next month. Thanks so much for the discussion today. It was really, really great, really interesting. Have a great month. We'll see you next month, and be ready to work because we're going to put you to work. Unless there is any objection. Did you have something? No? Okay. Unless there's any objection, I'm going to adjourn the meeting. Thank you. See you next month.
Great 2 weeks.
Yes.
It's just a different month.